child relocation. And before that, two things quickly. One, thank you for all your feedback, which is really appreciated. And if there's any specific questions, feel free to just drop us a quick email. You can email us and follow us at Talking Legal and YouTube channel, and just subscribe it so you would be the first one to get notified. On that note, also we are getting this live on the Facebook as well. So if there's any specific questions, feel free to just type or just message us at info@matthewlove.com.au. All right. So without further ado, let me welcome to Laura Muccitelli, Special Counsel from Matthew Love. Welcome to the show, Laura.
Thank you, Pravin. Great to be here again.
You bet. All right. So our viewers, obviously things have, this is a area, this is a topic which is always a confused, and it's a little bit complex even for normal people, or for obviously even for the normal audience. So let's talk about child relocation, if that's okay, Laura. So the first questions our viewers want to know about is, can a parent move interstate or overseas with a child, Laura?
Yes, this question, Pravin, is one of the most commonly asked questions of lawyers. And basically, there are laws about moving with children. So these laws apply even if parents don't have any court orders in place, which is particularly important to realise. The short answer to your question, Pravin, is yes, a parent can move with a child if the other party agrees. So if the other parent agrees. If the other parent does not agree, then the parents will need to talk to each other and try to agree. Okay? They must make a genuine effort to try and sort out an arrangement that's suitable to both of them and the child or children, usually with the assistance of mediation or family dispute resolution. If the parents can agree, and usually this can be done at the mediation stage, then we suggest that it's best to enter into a written agreement, a parenting plan, or consent orders that are filed at the court before the move. Before
the move. Okay. So what happens then if the parents moves without the agreement?
All right. So yes, that does happen. If a parent moves with a child without a court order or without the consent of the other parent, that parent, the remaining parent, can apply to the court for what we call a recovery order. So basically to ask the court to make an order to return the child to the other parent, the remaining parent, while the court is considering who the child is to live with and whether the child should actually go with that other parent. Now, in relation to recovery order, the Australian Federal Police usually are involved in returning children that have left with the relocating parent without the agreement of the other parent, the remaining parent, and without a court order. If parents can't reach an agreement, so say they've gone to mediation or they just don't have good communication skills with the other parent, then that parent should apply to the court for permission to move.
All right. Okay. So it's a bit sensitive, isn't it? I mean, you
Yes.
have to really be very, very. It really depends upon that. So that also means the court consider them deciding whether the parent can move the child. What does that? What does the court consider?
So if the remaining parent or the parent wanting to relocate applies to the court and says, I want to live overseas, and I want to take the child with me, the court must consider whether the move to overseas or interstate, or even to the same state but a couple of hours away, then the court must consider whether the move is in the best interest of the child, and this is balanced against the parent's freedom to move. Okay? That's it, really.
Okay. And then how does the court decide what is in the child's best interest? Would that something very technical without anything? Can you able to shed some lights there, Laura?
Yes. there are specific requirements, and that's contained in the Family Law Act. But just a summary, the court will consider, number one, the child having a meaningful relationship with both parents. So that means that the court's not focused on the amount of time that a child spends with their parent, but rather the quality of the time. Another consideration is that they would need to protect the child from harm or abuse or family violence. The child's views are taken into consideration depending on their level of maturity. Say, an over 10, 12, 15-year-old who doesn't want to move overseas, that's definitely given some weight with the court. The nature of the child's relationship with their parents and other important people in their lives, like grandparents. And whether the parents are willing and able to facilitate and encourage a relationship between the child and the other parent. This is particularly important. I recall a case that I had not long ago where mum and dad, they had a little girl at 5 years old. The party separated. Mum wanted to relocate. She was from South America. She was born there. She had family there. She wanted to move back to her home over there and take the little child. At the end of the matter, the court did not allow her to go back home. And one of the reasons that they specifically said was because mum didn't really like dad, and they couldn't communicate. And the court was concerned that she would not facilitate a relationship and facilitate time with the little girl, and especially as she was quite young. So amongst other things, she was not allowed to relocate with the child.
Okay, yep. So what you're saying, and just recap to our viewers, is quality of the time is very important. Child harm security, which is very much important. And obviously, as you mentioned very clearly, nature of the child relationship with parents as well as with family. What does that actually mean is child's best interest is, that's how court decide. Yeah?
Yeah, that's exactly right. And some other examples where, say, a relocation with the child has not been allowed is if the parent remaining has been involved in a high degree in decision-making concerning the child, involved in the child's life.
What does that mean, Laura? Sorry, just to break it up. And what does that mean exactly? Yeah.
So that means, say, if the child is, say, 10 years old and, the parties have been separated for many, many years, and say, and mum wants to relocate with the child, say, interstate, and dad's the remaining parent, and dad has, had a strong relationship and bond with this child and has made decisions concerning this child's welfare, for instance, schooling, religion, day-to-day care as well, day-to-day decision-making, basically played an active role in the child's life. It's possible that relocation may not be allowed. But having said that, that's just one of the criteria. The court, when they consider a child relocation, it's really a balancing act between the best interests of the child and the parent's freedom to move. So another instance where a relocation may not be allowed is the high cost and practical difficulty of the remaining parents spending time with the child. For instance, if, say, mum and the child wanted to relocate to overseas and dad is, say, a pensioner and cannot afford flights and accommodation overseas. That is a practical impediment to, dad having a meaningful relationship with his child. So that will be one of the factors where possibly relocation may not be allowed.
Okay, I think that's a very good example. Thank you, Laura. I hope, again, this is a quite sensitive and complex matters, isn't it, Laura?
Yes, it is. It is one of the. Sorry, Pravin, go ahead.
It is. It's always much in depth, and it also depends upon situation to situation and circumstances. Those viewers who are watching this, and obviously, if they have any specific questions, feel free to drop that. drop that in the chat, or obviously they can reach out to you and the team at Matthew Love. So the best email is here, info@matthewlove.com.au. Laura?
Yes, that's exactly right.
All right. Now, just before we go, actually, just one of the questions I just received it is just does the moving parent have to have a reasons to move? What's your thought on that?
Basically, in a nutshell, yes. Okay. The reasons for the relocation must support the best interests of the child. However, a parent who wishes to move doesn't have to give compelling reasons to move. Okay, so for instance, a parent can argue that relocating to another suburb or city is in the best interest of the child, as the child will have more support, better access to schools, some, access to relatives or family and friends, a better lifestyle. Then relocation may be permitted. On the other hand, on the flip side to that, this will be weighed against whether or not the relationship with the other parent will suffer, the remaining parent will suffer, as the child may not be able to spend more time with that parent due to the long distances between them.
All right. Okay, that's good. Thank you, Laura. Any final things you wanna touch that add on the child relocation that we haven't covered in a short time?
Yeah, just in conclusion, a parent shouldn't assume that it's okay to move with their child or children because there's no court orders in place. If a parent moves with their child without the other parent's agreement or a court order in place, then the other parent can apply to the court, as we've said, as a recovery order and force the child and the parent back. It's likely that that order would be made. So my advice is to try and agree and go to mediation.
So go to mediations. Okay, and also find the right team, the legal team from the day one. What's your thought on that?
Well, we're obviously the right legal team, Pravin.
Yes.
So here at Matthew Love Lawyers, we can certainly help anyone that's thinking of moving overseas or interstate and wants to take their children. Or on the other hand, if we do act for parents, the remaining parents that believe that the other parent that the child lives with is looking to move interstate or overseas, preventing them from actually spending some quality time with that child.
Beautiful. Now that's good. So you and your team, your trusted family legal team can help help the team. So the best way to contact is you have a 1-300 number as well. Yeah, Laura.
Yes, we do have a 1-300 number, and we've got the email address at info@matthewlove.com.au, or you can email me directly, just laura@matthewlove.com.au.
Beautiful. Laura, Laura at Matthew Love. That's good. All right. Thank you so much, Laura, for your time. And by the way, guys, if you're just watching this, all the past episodes, you can just find the link here, or no matter wherever you're checking from, either from Facebook or YouTube, just find all the past episodes link here. And if there's anything we can add value, so feel free to reach out to Laura's and her team. So thank you once again, Laura, and we will see you in the next one.
Thank you, Pravin.